name, please?
I'm Terry Smith, represent myself.
Okay, and this was a final pretrial. Is the complainant witness here?
But she was the one on Zoom who we,
Oh, over down there. Okay, got it. Okay, and so how the underlying matter, there was no offer, is that correct?
I believe there was an offer for 764, but let me double check.
Training tomorrow or something?
Yeah, the conference.
It's just one day?
No, Wednesday.
Oh, it's easy.
No, Friday.
Oh, can you send me my document? I'm sorry.
I think I just had resent them. Yeah,
Oh.
but I already sent them. Email.
It's fine.
We will be offering a plea, we'll be offering to dismiss count 1 and for the defendant to plead the count 2 under 769.24.
Okay. Dismiss count 1 and plead to count 2 under 769.4. Okay, so I record a receipt of what is perceived to be a motion for evidentiary hearing and to dismiss you filed. Okay, the court's read your motion. The basis of your motion you state is because the people or discovering your materials that you receive from the people do not establish the required course of conduct under Michigan Compile Law 750.411H because the alleged communication and contact were mutual and not solely one-sided. The parties had ongoing two-way communication, including calls and messages initiated by the complaining witness, which is consistent with a one-sided repeated harassment allegation. That may or may not be true. If it's even if it was true, I don't have the position to dismiss the case on that. That's when you go to a jury. They're the one to decide if it's your word over hers, who's right. So you're saying that there is evidence of some communication, but you say that the communication was both mutual. Well, then the jury will decide if it's mutual or not, okay? The other reason that you're saying is that the responding officer documented no visible injuries on the charge date, and the complaining witness stated she did not seek medical attention or require treatment that day. How is that a basis to dismiss a case?
I don't understand how you can contact the police and say that someone put their hands on you, but there's no evidence of.
Did you read the elements of a domestic violence? Because injury is not a element. They don't have to prove an injury.
Well, also, the officers also questioned me at most of those incidents, and I told them that I was attacked as well. And there's only arrest.
Okay, so then that sounds like what you believe is there's a possible defense to, but I'm just basing off what you said in limitedly, which is that you were attacked as well. And I'm assuming you're talking about in this particular instance. I don't want you to say too much. If that was the case, then it sounds like what you're asserting is a defense of self-defense, and that's also for the jury. Okay, and then you would just have to assert the defense, and then the people would have to prove that you did not act in self-defense. They have to prove that beyond a reasonable doubt as well. You understand that? Okay, last you said the photographs and videos were uploaded several days after the charge date and appear to contain mismatched dates in reference to separate incidents, including events outside the charged incident. That's
Being
not
charged with something that happened on May 31st, 2025, and there's incidents in the discovery that has nothing to do with the date.
You're talking about incidents of communication, is that what you're talking about?
Communication and pictures, and
Pictures of what? Of I don't know what you're talking about.
she sent pictures of bruises that have no context and they're out of.
Oh, so what you're asking is them to charge you with another count for that date? Because that's what they can do. If they have evidence or dates that there was alleged contact that caused bruises on another date that's not charged here, they can just say, Your Honor, I want to make a motion to add another count based on that. You know that? Okay. Not a reason for me to dismiss a case. Let's see, request for hearing. A defendant requests an evidentiary hearing regarding the admissibility timeline and relevance of the later photographs, videos, calls, logs, other evidence. I don't think that an evidentiary hearing is warranted in that case. If they, whenever they try to present evidence at a trial, that's when we deal with whether or not it's admissible or not. You can object if you don't think it's relevant. They can only admit relevant evidence. So they can't admit evidence from an incident that's not relevant to what they're trying to proceed on. You understand that? So your motion to dismiss the case is denied, and there's no basis to have a evidentiary hearing. I know I didn't allow the prosecution to respond. I did read your motion if you wanted to add any additional record.
Yeah.
So your matter is already scheduled for trial, I believe. It's June 23rd at 8 a.m. There has been an offer for you to plead guilty to the domestic violence charge. They'll dismiss the stalking. There's no objection to sentencing under 769.4A. That is a special status that if you do a successful term of probation, without any violations, the conviction of domestic violence will be non-public on your record. You understand that? Okay. And so you'll have time to consider that offer because it was just, I'm assuming it's extended today. So what I'll do is I'll let you decide and you can let us know. And I don't normally do this the day of trial. Okay? Okay, and so you're still going to be representing yourself at the time of trial, correct? Okay, you're gonna wanna read your court rules and your rules of evidence, okay? Understand some questions on how to pick a jury.
I'm unsure.
You're not sure, you might hire an attorney.
Hire an attorney.
Okay, if you hire an attorney, they'll follow their appearance and then we'll take it from there. But if you're going to represent yourself, make sure you read your rules of evidence between now and then, okay? June 23rd, 8 a.m. Any additional matters for the record?
Nothing wrong with people, Your Honor.
No, sir.
I give my notice to.
We can give you a notice, yes. That's the state of Michigan versus Isaiah Hollins. I have 26-00421 and then 26-00999. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people. Assistant Public Defender Joseph Hardy, here. Collins, who's standing here to my right.
Mr. Hollins has assault and battery and 26-00421 and then malicious destruction of property in 999. There's also 2 pending bond violations. One, it looks like he addressed the other one. And he was arraigned on the bond violation on May 13th by the magistrate. I guess he allegedly picked up a new case. Is that what the bond violation is?
Yes, and he pled guilty to that case this past Friday. The underlying charge of breaking and entering.
Okay, what are we doing on the underlying cases? On the other file.
On the underlying cases, it's my understanding that one of the counts will be dismissed, and that it is our intention to go to trial on the remaining assault.
It's your understanding that what?
It's the prosecution's understanding that there's only one count of assault left. Based on my looking at the online register, it appears that there were still 2 assault counts open.
I'm confused. Let me see here. For plea guilty on count 1, victim on count 2 failed to appear. Okay, that's what's going on. Looks like count 2 victim didn't appear for a final pretrial. Is that what it was? And there's a jury trial scheduled for May 12th.
Yes.
Okay, and we're continuing to trial.
Yes, and we would like to motion to dismiss on the count 2 and proceed to trial on count 1.
That's noted as a release. That's count 2. And then what are we doing with the MVOP?
The malicious destruction of property we'd like to set for a final pretrial.
June 15th, 8 a.m. June 15th at 8 a.m. Final pretrial. And jury trial July 14th. July 14th, 8 a.m. for jury trial. Any additional matters for the record?
Nothing from the people, Your Honor.
You're all set. Thank you.
Oh, one regarding Mr. Collins's bond that was currently set at 1,000%. We would like to motion for modification to a PR bond.
Why? So he can pick up another case.
When I was here Friday, I was, I don't want to say told, but as if it was a promise, but I remember it said it'd be amended next time I came.
What will be amended?
Bond.
So I'll address your bond. I don't promise to amend people's bonds.
No, that's, I'm at the lack of intellectual probability.
I don't know what happened in this case last week. What happened last week?
It's my understanding that he pled guilty to the one of the counts breaking and entering.
Nah, I think I vaguely remember. Did you meet with probation to do a PSI?
Not yet.
I think that's what I said. I said that I would not amend your bond until after you met with probation to do a PSI. Just I don't have time to track it down to get that done. They have not done a PSI. Your bond is 1,010%, which is $100. And that was after you had a PR bond, but then got a violation.
This was unlawful entering. When I was out on a PR bond, I attempted to show to my brother's house. I thought he was in the house because I seen people I wanted to surprise him. And it turns out that the people that I seen were his girlfriend's kids. So they got on the phone with their mom, and their mom told them to call the police. It was not like breaking and entering, but the police grabbed me for that. It was a misunderstanding.
You pled guilty, didn't you?
Yes, ma'am.
So it was like breaking and entering or unlawful entry.
Well, I
You
wanted,
pled guilty to that.
I wanted to get it out the way. I didn't want it to seem like. I
No,
was
no, no, because
neglecting
actually you're pleading
responsibility.
guilty because you believe you're guilty. And you said yes.
Well, because I wanted to have responsibility for
Because you believed you were guilty.
part black and white, you know what I mean?
Because you believed you were guilty.
Because the adults weren't there. From what the adults could say,
What's that got to do with the other case that you picked up? Which was why what we're studying for final pre-trial.
malicious destruction.
Yeah, that happened allegedly on April 11th, which
That hasn't
you would
been,
have been on bond, no? No?
Sure, they would have been.
So there's two alleged bond violations for picking up while you're out on bond. So I think, I mean, and your bond in that one is 2,010%. Because at that point, you had 3 cases pending. It's like, you're actually getting great bonds under the circumstances. These are phenomenal bonds, they're really low.
I'll show you, there won't be an incident otherwise.
I know there won't, but you don't want to sit in jail on a sentence. I'm not amending their MDOP bond. I think that that's appropriate. You need to pay to get out. And then there's no reason for me to amend the assault and battery if you're just gonna be sitting there because you're not getting out on the MDOP bond. You're not eligible for a personal recognizance bond if you're picking up cases while you are out on bond. That means you don't have the ability to keep yourself in line with the court order. And that's why we have had multiple cases during this time. So you need to post a bond. Any additional matters for the record?
Nothing from the people, Your Honor.
Anything else, Mr. Hardy?
No, Your Honor.
Thank you. Why does it start off this way?